Our presenters today are Peter Watson, who's the Senate Counsel and the Secretary of the Senate Legislative for the state of Minnesota. Peter serves as the Senate Counsel to the Committees on Rules and Administration, Finance, and Capital Investment. And since January of 2009, he's also served as Secretary of the Senate Legislative Secretary. In 1995, he spent 2 weeks in the former Soviet Union as part of a team from the National Conference of State Legislatures that taught bill drafting to the members and staff of the legislatures of Kyrgyzstan and Moldova. In 2009, he joined an NCSL team teaching bill and policy analysis to members and staff of the People's National Assembly of Algeria. He's preparing for his fifth decade of redistricting. And before working as a VISTA lawyer for the Minneapolis Legal Aid Society in 1969 to 1970, Peter received his law degree from the University of Minnesota in 1969 and his Bachelor of Arts in Government from Harvard in 1966. Our other presenter is Professor Stephen Huefner from the OSU Moritz College of Law in Ohio. Professor Huefner is on the law faculty of The Ohio State University Moritz College of Law, where he's Director of Clinical Programs and Director of the Moritz Legislation Clinic, as well as a Senior Fellow of Election Law at Moritz program. He teaches legislation, jurisprudence, and legal writing. His research interests are in legislative process issues and democratic theory, including election law. Professor Huefner has published a number of articles and one book, From Registration to Recounts, The Election Ecosystems of 5 Midwestern States, co-authored with his election law at Moritz colleagues. Before joining the Moritz faculty, Professor Huefner practiced law for 5 years in the Office of Senate Legal Counsel, United States Senate, and for 2 years at the law firm of Covington and Burling in Washington, D.C. He also clerked for Judge David S. Tatel of the United States Court of Appeals for the District of Columbia Circuit, and for Justice Christine Durham of the Supreme Court of Utah. Professor Huefner earned his J.D. in 1991 from Columbia University in New York City, where he was a Harlan Fiske Stone Scholar and served as head articles editor for the Columbia Law Review. I'll go ahead and start with Peter first.
Thank you, Lisa. As your program says, we're going to talk both about ancient history and current events. And one of the things I want to do is go through my paper on legislative immunity in Minnesota, and I don't see that everybody has it. Is it indeed on the back of the, many people have it. If you don't have it, please get it, because we're going to be zipping through that in a hurry, but it'll be in the main text. Now, the first time I delivered a paper of this nature was at the NCSL annual meeting in Detroit. Who here knows what year that was? Detroit.
1977.
Exactly right. He gets the prize. So over the years, as I've given this, there are probably several people in the audience who have heard most of it before, but not everything, because I always go back and do a search of the latest cases, and this most recent time, a couple weeks ago, I did a search, and it was over the last 2 years, and I came up with some new cases, about 20 new cases. And one of those cases was the kind of case that I hate. It's another congressman who is seeking to use legislative immunity to avoid criminal prosecution. And in this case, it was Congressman Rick Renzi of Arizona. Anybody from Arizona? No Rick Renzi? Yes, yes. So he had moved to dismiss an indictment, and on February 18th, his motion to dismiss was denied. The allegation that he made in his motion was that the indictment was tainted by evidence of his legislative activity in negotiating with a citizen over the terms of a land exchange bill. And the evidence he sought to get excluded was evidence that he had refused to introduce the bill unless the citizen, constituent maybe, agreed to purchase a particular piece of property as part of the land exchange transaction. First person he talked with said, I'm not going to do that. Second person he talked with, or a later person said, I'll do that. They paid $4.5 million or so, bought the property, and what the evidence showed was that after the purchase, $700,000 went from the property owner to a company that Renzi controlled, and then it went from that company's account into Renzi's personal accounts to pay his bills. And he said that that should not be included in the evidence because it was a legislative activity. The court ruled against him, and by the time I'm done, I hope you will know why. Now, that was February 18th. Search of the news reports showed that on July 9th, recently passed, his accountant was convicted, but as far as I know, his case has not yet gone to trial. Do we know when it? No, not gone to trial yet. So if you see the name Rick Renzi in the news in the next several months, note that's a legislative immunity case and see what happened to him. So Steve and I are going to give you almost everything you need to know about legislative privilege and legislative immunity. I'm going to be sprinting through my paper here, essentially letting you know in a general way what's in it, and then Steve will go into some more detail about particular issues where the courts are in disagreement on what legislative privilege and legislative immunity mean. Our goal is to help you prepare for a rare event. And I say rare because what I'm talking about is when a member or employee of the legislature finds themselves in court by summons or subpoena because of something that they have said or done within the sphere of legitimate legislative activity. It's a rare event because even though, I've been with the legislature for 40 years, I've been in court maybe 10 times in 15 years, only 3 times in the, 10 times in 40 years and 3 times in the last 15 years. How many of you have been in court on an issue of legislative immunity? A few, but probably not very often. So our challenge is to make you acquainted in general with the doctrine so that you know that there is something there and will seek out your materials when the time comes for you so that you can educate yourself in detail at that time. Look for the latest version of my paper on the web under legislative immunity, and you'll be well prepared. I call it the silver bullet because legislative immunity, when raised, is very often successful. Not for Rick Renzi, but for most people, it is successful. The silver bullet is meant to kill the bad guys, not the good guys. But it's also a silver bullet because, it was the Lone Ranger who had the silver bullet. Does everybody know who the Lone Ranger was? And he was the only one in the territory. And you're likely to be the only one in the territory or near the courtroom who knows anything about legislative immunity. So you can maybe surprise some people, but it's a powerful defense. But since you won't need to know it probably for another 1, 2, 5, maybe 10 years, you need something to remember that, and so I created the little mnemonic: summon, subpoena, silver bullet. Summon, subpoena, legislative immunity, maybe that would be better. As I shall explain, legislative immunity is a doctrine grounded in the common law. And that means that the decisions of the courts of one state have an impact on the courts of another state. So we who serve the legislature have a common obligation to try to defend those cases in every court, because if we lose because we haven't done our best job in our court, that's going to hurt everybody else in the future. Bad precedents. Now, the common law goes back a long way, and so does the legislature in the English-speaking world. The common law was started by, here's our ancient history, Henry II, who ascended the throne in, everybody know? 1154. 1154. To extend and consolidate his authority throughout the realm, he appointed judges to serve at his pleasure. Those judges rode circuit from castle to castle, holding court in the courtyard and dispensing the king's justice. And because the same judges were making decisions throughout the realm, there came to be a common law. They tended to follow their own decisions. When Henry died, his son Richard the Lion-Hearted became king. They called him the Lion-Hearted because he was so brave in battle. Among the things that he did was he led an army to the Middle East to subdue those Muslim infidels. Where have we heard that before? He had great press and got the name of the Lion-Hearted, but he didn't have great intelligence. And on the way home from the Middle East, he was captured and held in a tower until he was ransomed. Now, after he was let out of the tower, he engaged in more battles, including a battle in France in which he was killed. And you all saw that scene in Robin Hood released this Christmas. How many have seen Robin Hood this Christmas? Yeah, remember, he died, right? Did you notice the scene about legislative immunity in Robin Hood? Probably not. Probably not. But remember, the coronation scene. Robin Hood is in league with the nobles and the clergy to put evil, we know how evil Prince John was from earlier Robin Hood movies. Well, they were going to put him in this movie on the throne as the king. And he said, oh, you do that, and I'll honor all of your ancient privileges and immunities. They put him on the throne, and in the movie, they present him this charter to sign. And he says, no, I think not. And he goes back to doing nasty things. Now, we all know eventually he did sign the charter. They called it the Great Charter. What year? 1215. Gold star. Maybe that'll be in the next Robin Hood movie. This is the first instance of an executive, a monarch, a king, agreeing to be subject to limitations on his power by a legislative body. See, in the Magna Carta, he agreed to not impose certain taxes without the consent of the realm, to be granted by a convention of the nobles and the clergy, that he agreed in the Magna Carta he would convene a parliament to approve his acts of taxation. Now, legislative immunity is not all about legislators being thrown into prison, but legislators in prison are a recurring theme from the earliest times to the present day. In particular, I learned when checking current events on Rick Renzi that since 2000, 5 former members of Congress have served time in federal prison for their legislative activities. You all know William Jefferson of Louisiana, $90,000 in the freezer. Randy Duke Cunningham, Mr. Top Gun, Tom Cruise portrayed his life as a Navy pilot. 8 years for accepting $2.4 million in bribes to carry legislation. Jim Trafficant of Ohio, remember him speaking on the House floor with the bag over his head? Let's see, he had 7 years. Bribery and racketeering. Frank Balance of North Carolina, 4 years for conspiracy to commit mail fraud and money laundering. And Bob Ney of Ohio, Jack Abramoff's good friend, just 1.5 years for bribery and conspiracy. Now, legislative immunity is not all about keeping corrupt legislators out of prison, as you'll see. It's about keeping good, honest legislators out of prison for engaging in legitimate legislative activity. In the old days, that was a serious problem. As we all know, businesses don't like to be regulated, and sometimes they use their political power against members of the legislature who try to regulate them. Take a look at page 1 of my paper, and in the middle of the first paragraph, you'll see that in 1512, a county court in tin mining country convicted a member of the British Parliament of having introduced a bill to regulate tin mining and imprisoned him, as you'll see in the footnote there, in a dungeon and a deep pit under the ground in the castle of Lidford for having proposed the bill. Parliament passed an act annulling the judgment and declared void all suits and proceedings against him and every other member of Parliament. Later kings granted members of Parliament the right to speak with impunity until Charles I started throwing people into prison in the early 17th century. Then there was the late unpleasantness of the English Civil War, where Parliament raised an army and freed those members who had not already died in prison. They freed them, and finally the issue was not settled until Parliament had Charles I beheaded. We usually think of the common law as judge-made law. Legislative immunity is one part of the common law that was written in blood with quills of iron. The members of Parliament were no fools. They learned from experience. After the Glorious Revolution, when they invited William and Mary to take the throne, they asked them to sign a piece of paper before the coronation that guaranteed the English people their ancient rights and privileges. And after the coronation, Parliament passed an act, the English Bill of Rights we call it, and it was signed by the king. It received the royal assent. And one of the clauses said that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. That same idea was carried over across the pond to the colonies and included in our Constitution, Article 1, Section 6, as for any speech or debate in either house, they shall not be questioned in any other place. And there is language similar to that in the constitutions of about 43 states. The U.S. Supreme Court articulated the reasons for the privilege in Tenney versus Branhope, you'll see there on page 2. In order to enable and encourage a representative of the public to discharge his public trust with firmness and success, it is indispensably necessary that he should enjoy the fullest liberty of speech and that he should be protected from the resentment of everyone, however powerful, to whom the exercise of that liberty may occasion offense. Legislators are immune from deterrence to the uninhibited discharge of their legislative duty, not for their private indulgence, but for the public good. One must not expect uncommon courage even in legislators. So we have these many state constitutional provisions, and on pages 4 to 6 of my paper, you'll see a table that lists the states whose courts have interpreted their speech or debate clause in light of the federal court interpretations of the U.S. Speech or debate clause. Now there on top of page 7, you might notice that Wisconsin is one state who has said, well, we're not necessarily going to follow what the federal courts say. They've got their constitution. Other states have their constitutions. We're going to construe ours. But in the main, state courts have followed the decisions, both of the federal courts and of other state courts, construing their constitutions because these are all based on the common law. There are still a number of states that have not had a case, and this number is 15, and Steve might even have a lower number than that by now, where the case, it just hadn't come up yet. So maybe that'll be in your jurisdiction, and if it is, I hope you have the benefit of this learning so that you can get the right kind of decision. Now on page 8, you'll see that there are a number of states that I've found so far that have statutes creating a legislative immunity, a sort of a speech or debate clause in the statute. Well, what does this legislative immunity cover? What's it all about? It's about protection for what a member or an employee of a legislative body does in the way of legitimate legislative activity. And the courts kind of encapsulate that with the term legislative act. So what is a legislative act? It's kind of all the things that you would think of would be a normal legislative act. And what the paper does on pages 8 to 17 is list all these things in an outline form and gives you dozens of cases interpreting this language and exactly what it means. So look to this. If you get sued, there'll probably be something that's pretty darn close to the fact situation that you are faced with. Just ticking through these, you'll see introducing and voting for bills and so forth. I won't read all the rest of these, but you'll see on the list here on the screen what they are. All the normal kinds of things that a legislator engages in when doing legitimate work. Let me pause, though, with personnel decisions, because they're particularly tough. That's on pages 16 and 17. It's tough because whether a personnel decision is a legislative act that is protected or an administrative act that is not protected depends both on whether you're talking about a member of Congress and the federal speech or debate clause, or whether you're talking about state speech or debate clause or local legislators, both on that, and on the nature of the duties of the employee is the employee doing something that is intimately related to the passage of a law, like the committee staff would be and a member's personal staff would be? Or is it something that's more distant, such as the work being done by the IT office or work being done by somebody paying the telephone bill? The cases are not particularly consistent, and maybe Steve will talk something about that, but many personnel acts are administrative. Also be aware, when thinking of personnel actions, you at the state legislative level and below are subject to things like the Equal Employment Opportunity Act, the Fair Labor and Standards Act, the Americans with Disability Act. All those federal laws that regulate employment apply to you, and there is no immunity for decisions in those cases because you are subservient. The supremacy clause is controlling, and when we're talking about a relationship and a duty imposed by the federal government versus a state legislature, we're not talking about separation of powers. This is not co-equal branches. They are unequal, and the federal law is supreme. So beware of those personnel cases. Now, legislative immunity, when it appears, is absolute, and that's a good thing. And why is that necessary? It's because the immunity is not qualified, because to take it away based on an allegation that the legislator or staff person is acting in bad faith would subject the member to the distractions of a trial, perhaps, on the issue, when they ought not to be distracted. This is important to just leave them alone. If they're within their sphere, they're entitled to dismissal of the complaint or quashing of the subpoena. The immunity is personal. It belongs to each individual member of the body to assert or waive as that member chooses. There are some cases that Steve will talk about where the court has extended it to a whole body, but in general, it's personal. It's continuing in that conduct that you engaged in while you were a member or a staff person of the legislature continues to be protected after you are no longer a member or employee of the legislature. Not things that you do after you leave, but the things that you did when you were there continue to be covered. And it's functional in that it applies to anybody who is participating in the legislative process. That's not just members of the legislative branch. It can be members of the executive branch, such as the governor and executive staff who are working to prepare a bill for presentation to the legislature, working to lobby on a bill. Extends to the governor making a decision to sign or veto a bill, because that's part of the legislative process. Extends to members of the court when they are adopting rules and regulations to govern members of the bar, for example. That's a legislative activity, so they are entitled to legislative immunity. And it extends to private citizens who are appearing to give testimony at a hearing, provided the testimony is relevant to the committee's inquiry, and the committee's inquiry is something that's relevant to legislative duties. There are actions that are not immune, and one category is actions taken without lawful authority, and the easiest one is ones that are taken without constitutional authority. When there is a question whether a bill has been given readings on 3 separate days or not, that issue is one of whether they complied with the Constitution, and evidence of that may be admitted in court. Whether a hearing has been held in violation of sunshine law, not at the time noticed, that is something that can be inquired into by the court. Illegal investigative procedures. If the committee issues subpoenas after its term has expired, then that can be challenged. If they seize documents without a subpoena, especially when the documents are irrelevant to the committee's authorized inquiry, those are not entitled to immunity. False disclosures, especially claims for money. If you're asking for reimbursement for travel expenses, the evidence on which that claim for reimbursement is based may be inquired into in court. There's another category of acts that are not immune, and that's what the courts have called political acts. Well, what are political acts? Well, let me talk first about the bottom four. Communications to the press. Example, you hold a public hearing. You make statements at that hearing. The hearing is over. You talk to the press and repeat those statements. What you said in the hearing is protected from any kind of questioning or liability. What you say to the press afterward is not protected. Communications to constituents. You have a newsletter that reproduces all those wonderful statements you made on the floor or in committee, evidence of bad conduct by somebody. What's on the official record is protected. You can't be asked about that. But if you republish it as a newsletter, you can be sued. Pressure on the executive branch. Working with the executive branch to pass a bill, that's protected. But pressuring the executive branch to give special treatment or maybe appropriate treatment to a constituent, no, that's not what they consider to be a legislative act. It's not connected with the passage of legislation. It's perfectly legitimate, but it's not protected. Travel on legislative business is perfectly legitimate, but it's not protected. Now let me talk about solicitation of bribes. Nowadays, legislators don't get thrown into prison for introducing a bill to regulate the tin industry, but they do get thrown into prison, as at least those five most recent examples shown, and there are many more going back further, for accepting or soliciting bribes to introduce bills to benefit business. They're not prosecuted, and this is the key, for their legislative actions in actually introducing the bill or voting for the bill or making sure that the bill gets enacted by lobbying for it. That's off limits. That cannot be introduced as evidence as part of an indictment. It can't be introduced as evidence in a trial. What they get prosecuted for is the promise to perform a legislative action in return for money or favors of one kind or another. And as long as they are trying to prosecute, for example, Congressman Renzi for his promises and refusals in connection with what he's going to introduce in the way of a bill, that is admissible. But the fact that he may have introduced a bill and that it may have passed, that is not admissible, can't be the grounds for a suit, and if the suit were, or the prosecution were based on that, it would have to be thrown out. William Jefferson's problems in that regard, the evidence that they were gathering when they searched his Capitol Hill office, and how they had to sort it out between privileged material that they could not look at and non-privileged material that they could look at. That's discussed on page 42. But don't turn there yet, because we're not there yet. Let's see, now personnel decisions, as I said, are the most common kind of administrative act for which members will be subject to questioning. And at the local government level, where we're dealing with common law legislative immunity, they are likewise protected for their legislative acts, but they do things at a city council that are different from the kinds of things that a legislature does. In particular, they do zoning ordinances and they grant variances, that kind of thing. Granting an individual variance may be done by action of a vote of a body, but the courts don't consider that to be legislative. They consider that to be administrative. So your actions on that zoning variance will not be protected. To be protected, the action has to be both substantively legislative, that is, it must be considering facts that are applicable to a broad category of people, and usually of future effect, sometime distant, and they need to be done in a procedurally legislative way, such as by the vote of a body. What's immunity good for? It's immunity for relief from a criminal prosecution, civil liability, declaratory judgments, etc. All these kinds of things you can use immunity for. It's also useful for not having to give testimony or produce documents in criminal actions or in civil actions. The rules are a little bit different depending on whether you're talking about members of Congress, state legislators, or local legislators, again, because of this federal supremacy. And if you're talking about a civil action or a criminal action involving a state legislature brought by a federal prosecutor, there is no separation of powers concern in that, and no immunity. What kind of relief can you get? You can get the indictment dismissed, you can get the civil complaint dismissed, and if it's a subpoena, you may ask that the subpoena be quashed, and maybe you'll get that. My experience has more often been that the judge will grant a protective order prohibiting the questioner from questioning the legislator or legislative staff about anything said or done by them in connection with the legislative process, which is usually the reason why they're there, the legislative process. Okay, skipping toward the end, you'll see cases again covering each of the things that I have just mentioned, plus there's material on waiver of the immunity. It is possible for a member to appear, this is on page 54 now, for a member to appear in court many times voluntarily and then say, oh, I'm going to assert immunity, I no longer want to talk, and the courts will generally uphold that. And that happens more often than you'd think. I have noticed that it's often not raised at the beginning of the proceedings, and sometimes it's not raised at all. There are a couple of cases where the court raised legislative immunity after the parties had not even raised it. They said, but we actually think there might be legislative immunity here, and so we take this action. What it's important for us to do, I think, is to avoid an unknowing waiver. Let people know that they have that immunity, that privilege that can be raised, and get them to raise it and raise it promptly so they don't get into this problem of having waived it. What I do to try to bring this to people's attention so that I hear about the cases is during new member orientation, we talk about legislative procedure and so forth, but then I just mention legislative immunity. I give them a copy of my paper, and I just tell them, if you get served with a summons or a subpoena in an action for anything you've done as a member of the legislature, give me a call. You probably have a defense. I like to say, often I don't hear about these things until they've gone a ways, but when I hear, we get involved and tell them, we've had a policy since 1976, the first case that I got involved in our office, always resist. Do not give any testimony under oath. Do not produce any documents not already public. Sure, there may be nothing in the file, as was the case in 1976, but we wanted to establish the principle that we just don't cooperate with that kind of thing. Now, we do cooperate in the sense of helping people find what's on the public record. We show them how to do a legislative history. And we've developed forms for certifying a record of a hearing or a copy of a bill or a tape of a meeting as an official record so that the plaintiff can go into court with their evidence and they don't need a live body to prove it. They prove it as an official record certified by us. I hope I have told you enough that you will remember, if you get a summons or a subpoena, remember the silver bullet, always resist, defend the honor of the legislative institution. Thank you.
Thank you, Peter. For a moment, I'm going to stay in my seat while Peter turns into the AV specialist, and I can stay near this computer monitor for a minute, and then if it works, I'll jump up in just a second. But while we're doing that, I want to just be noting a couple of things. I mean, I'm planning, as Peter said, in part to try to identify some points of uncertainty about the scope of the legislative privilege in state legislatures, and to reinforce in part some of what Peter has said, but with a slightly different organizational framework. Good. So let me stand and do this. I come at this issue with a sense that in state legislatures in particular, there are occasions when the value of the legislative privilege is overlooked or neglected. And that's what I've titled my slides for today. It's also the title of an article that I wrote about 8 years ago. And it was reflecting my sense at that time as I was transitioning from having served in the U.S. Senate for 5 years to working closely with the Ohio legislature, that many state legislators and legislative staff were sometimes unknowingly waiving the privilege, or at least ignoring it in ways that Peter has described. And in fact, when Peter asked the question, how many here today have had the unfortunate experience of being the subject of a subpoena or a summons or some other judicial inquiry into their legislative activities, we only saw, I think, about 4 hands go up. I actually would be surprised if there weren't more than 4 people in the room who could have invoked the legislative privilege at some point on behalf of yourself or your boss in some capacity or other. And so part of what we want to do is to help make you as aware as we can about the role that this privilege plays. Now, let me just describe in slightly different ways what I would identify as the purpose of this legislative privilege. And Peter shared the quote from Tenney versus Branhove, this sort of foundational U.S. Supreme Court decision interpreting the speech or debate clause in the U.S. Constitution. I'm sharing with you a quote from the first state court interpretation of the analogous state privilege, a Massachusetts decision from 1808 interpreting the provision in the Massachusetts Constitution that predates the U.S. Constitution. And there, the Massachusetts court explained that the privilege exists not with the intention of protecting the legislators against prosecutions for their own benefit, but to support the rights of the people by enabling their representatives to execute the functions of their office without fear of prosecutions. And I would describe this as, in fact, in part, keeping honest members out of prison, to borrow something Peter said, but also as much more than just that. And other ways that I think it's valuable to reformulate the purpose of the legislative privilege include making sure that legislators are protected from the resentments of the executive branch, with whom they may often be at odds, as well as disgruntled constituents. And protecting them in that way allows legislators to remain undistracted and focused on their legislative work. It also provides them relief from the distortions that can come if they are, in fact, having to deal with subpoenas, summons over their official legislative duties. And I also think that it's really critical to reflect upon the value of protecting a certain element of confidentiality in the legislative work process. And I see this as closely related to the question about open government. And I know there was a nice panel talking about ways to make aspects of the legislative processes more accessible to the public. And in general, I think that's the right direction for us to be moving. But I think it's a direction that is not one to just take unilaterally. I think there are important points in the legislative process when the legislators themselves and their staff need to be sure that what they're doing is not going to be released to the public if they don't want it to be. And that's a hard issue to get the public to understand, and it's a hard issue to draw a line for, even for legislators, I think, at times. There is this very strong competing good government pressure in the sense that citizens have a right to know what their representatives are doing. But at the same time, as we heard this morning, too much of that leads to a situation in which, for instance, no one keeps records anymore. Don't write it down was a response that we heard this morning in the open government session. And in fact, Peter's colleague from Minnesota explained that with respect to the governor's office, I think if I heard the numbers right, the governor's office in Minnesota has now been generating about a 90% smaller volume of documents than the governor's office of 2 decades ago did. And that's a dramatic change in the way in which public officials are conducting their affairs out of a concern that sometimes something is going to be public that shouldn't be. And related to that is this notion that a good legislator has nothing to hide. But again, there's an important role here for education and helping the public to understand, and maybe this is a fool's errand, I don't know, and maybe legislators and legislatures are just sometimes going to have to make their own decision about what to release and what not to release because of public pressure to release it. But it should be their decision and not the court's decision about what's going to be released if it has to do with their official legislative activities. That allows legislators to engage in their legislative activities with some real freedom and independence. There's a Ohio legislator put it this way: you're going to have dumb ideas along the way. Your enemies in this business are going to take them and use them for nothing that is for the public good. I want legislators to feel empowered and not to be pilloried for the dumb stuff on the way to the creative stuff. And again, this morning, I know that the clerk from New South Wales talked about how the media can manipulate some things. And so I do think there's a value in, with respect to what is protectable under a legislative privilege, for it to be protected as a general rule. Now, I might not go quite as far as Peter in saying that as a blanket rule, you should always refuse to turn over material. When I was working in the U.S. Senate, we had a sort of similar approach at the outset, to always resist at the outset. But I know that our office there would advise members on a case-by-case basis about circumstances in which it clearly was to the public good for a Senate office, an individual senator perhaps, to release documents that were clearly protected by the speech or debate clause, could not be compelled to be turned over, but that still the interest of justice would be served by going ahead and releasing them. But we only made that advice after careful consideration because we wanted to help sort of lay the marker down and keep the markers down that this privilege exists, and to continue to reinforce the purposes for which it exists. There is a robust speech or debate clause jurisprudence interpreting the federal privilege, and it makes clear some of the things Peter has already described, that the privilege is absolute. It's not a defeasible privilege. It's absolute where a senator chooses or a representative chooses to assert it, and should be interpreted broadly. It's a privilege that applies both to liability immunity as well as to testimonial privilege, but at the same time that it should not be extended beyond what is necessary to protect the legislative process. And there, too, there are often interpretive issues about the extent to which a particular official activity of a legislator is a legislative activity as opposed to a constituent service activity, for instance. But notwithstanding the robustness of the speech or debate clause jurisprudence interpreting the federal clause, at the state level there is a dearth of judicial interpretation of the analogous privileges. My slide says there are 17. My numbers and Peter's aren't in complete alignment. I'm sure when I go back and look that my number will come down maybe to 15. I think Arizona is off of Peter's list because the Arizona Independent Redistricting Commission has given rise to a question about the privilege, and I may not have included that here because it wasn't actually directly interpreting the applicability of the Arizona immunity to state legislators. I think Utah has had something that I just missed. But the most recent interpretation comes out of the state of Montana from just a few months back, And it's really interesting to me that the Montana case is kind of a bookend to the Massachusetts case of Coffin versus Coffin that I quoted at the beginning. Both of these cases involved defamation actions in which a private citizen was suing a legislator for a statement made by the legislator on the floor of the legislative chamber that the plaintiff asserted was defamatory. And in the 1808 Massachusetts case, the court there, although elaborating on the purpose of the privilege in a very robust way, decided that it did not apply to the statement that that legislator made. Now, that legislator's statement was, I think, made not to the full body, but was made just to a colleague in more of a private colloquy, but on the floor of the legislative chamber. Meanwhile, in the Montana case from earlier this spring, the allegedly defamatory statement was made as an exercise of the legislator's right to make a point of personal privilege on the legislative floor. So in some sense made more officially, made to everybody. And the court there said that it was fully protected by Montana's legislative privilege. But generally, there are not a lot of these cases out there. And in any given state, you're not likely to find very many at all, with a couple of exceptions. New York and Pennsylvania have at least a dozen interpretations now. So instead you have, states where a question comes up, wrestling with what their privilege is going to mean, looking at what other states are doing, looking at what the federal privilege has been interpreted to cover. And I have this set of slides also available, a handout. I'm going to, I think, move through pretty quickly and not necessarily talk about all of these things, or at least not in much detail. But some state courts, in contrast to the federal jurisprudence, have limited their legislative privilege to only provide a privilege from being named as a defendant in a court action, as opposed to extending it to also shield legislators from having to turn over documents in response to a discovery request or a subpoena or something like that. Or, alternatively, to extend it to suits seeking only declaratory or injunctive relief, which the federal privilege clearly does provide. And sometimes you get conflicts on this within a single state, and I'll just briefly allude to one of those. New York State has a 1984 case in which the court wrote, as long as there is no threat of prosecution, so in other words, if the legislator is not being named as a defendant, legislators must come forward when summoned and give an accounting when asked. And then 15 years later, a New York trial court, without even acknowledging the earlier ruling, reached the opposite conclusion in extending a testimonial privilege for actually an executive branch employee doing work on behalf of a state legislator. That last case also then gets us into the question of the extent to which the privilege covers just legislators or others also working on their behalf, or in fact the entire legislature. And as Peter mentioned, there are some states that have extended the privilege to the entire legislature. Other states continue to limit it just to the individual legislators themselves. And furthermore, in some states, whoops, I just blasted there too far, didn't I? Well, I'm not going to go back in the slide, but the slide I just skipped over notes that in some states, thanks, Peter, the privilege has not been extended to staff. And in fact, now that Peter's got this slide, let me just note the DeRolf decision, that's the first one listed here, is an Ohio case. And this is an interesting case, even if I weren't from Ohio. This was a school funding issue that was before the Ohio Supreme Court for close to a decade and went up and back a few times. And in the course of this litigation, individual staffers were forced to talk about the legislative response to the court's first decision finding the funding system unconstitutional. The decision I've cited here is actually not the best one for that point. In this decision, all that really was happening was that the court was rejecting the assertion of legislative privilege with respect to a large scope of discovery requests, but yet leaving open the possibility that the legislative staff could come back on a case-by-case basis. And I've sort of overstated that with respect to this particular decision, but it's nonetheless the case that in an earlier decision in this same case, key legislative staff were talking about specific aspects of the legislative response after having their assertion of legislative privilege rejected. Other states have agreed with the federal approach and extended the privilege to cover legislative staff. And let me jump on to the next slide and talk about the information gathering process. Federal courts have uniformly concluded that the legislative privilege covers congressional efforts to collect information and analyze information and communicate about it within the legislative branch. There are some state courts that have agreed with that approach. There's a Connecticut court that's one of the more recent ones doing just that. But there was an Ohio decision not too long ago, and this I've slightly changed from this printout just to make it a little clearer as well. An Ohio court required legislators to disclose their sources of legislative information. So you see why I'm talking about how the legislative privilege is neglected in some ways or in some cases at the state level. Now, what the court here did was to say, at least as far as protecting against disclosure, the privilege didn't apply. And the court seemed to say it was making a distinction between being required to disclose versus being required to provide evidence. Now, if you're a legislator, you're not going to see much distinction between that in terms of the values that you want the legislative privilege to protect. You want the legislative privilege to allow you to conduct some of your legislative strategizing and deal-making without fear that another branch of government is going to be able to force you to disclose why you're doing that. Now, I'm talking again about another branch of government. I'm not talking about your constituents. Legislators are accountable to their constituents and may well want to provide as much information to constituents as the legislator voluntarily wants to disclose. But again, there are real trade-offs in being subject to a court compelling you to talk about your motivation for a legislative act, for instance. As Peter noted, the speech or debate clause generally and certainly at the federal level does not protect republication of otherwise protected information. That is, when you take your comments that you make on the floor and turn them into the press release and release the press release, that's generally not protected, certainly not in federal law and not in most states. There are a couple of now somewhat older state court decisions that have gone the other way. Hawaii and Oklahoma have at earlier points protected communications with the media. I'm not sure whether those court decisions would come out the same today in light of where the federal jurisprudence has gone. Some more recent cases include a Pennsylvania case that follows the federal jurisprudence. There was clearly one state court that, in my view, went quite a bit too far. New York has a case from 2002 in which they extended the legislative privilege to keep a political party from using a representative voting record as a basis for party discipline, which raises some interesting issues for parties and party loyalty and so forth. Now, let me wrap up with just two other wrinkles on legislative privilege. We're focused on the legislative privilege as it protects state legislators, and what I've been talking about primarily has been protection that would be afforded under a state constitutional provision analogous to the speech or debate clause of the federal Constitution. But state legislators may also have, and do also have, at common law some additional protections. One category is important to the 7 states that don't have in their state constitution an express legislative privilege provision, but many of those states have already had issues of legislative privilege come up and have extended a similar sort of protection using common law principles. But in addition to that, state legislators have been found to have a common law privilege in federal law that provides them with immunity from civil liability in federal court and also from testimonial privilege in federal court. But there's one important difference about this common law privilege, federal common law privilege for state legislators, which is sorry, I'm showing you the wrong slides. I'm not showing you the slides I'm talking about at the moment. Let me just jump ahead to the slides I'm actually talking about. This is the slide I'm talking about. So at common law, there is this privilege for state legislators with respect to civil issues in federal court. But there is no federal common law immunity for state legislators with respect to federal criminal charges. It's really sort of a supremacy-based argument that if a federal indictment comes down against a state legislator, this common law privilege is not going to do the legislator any good. And that means that in that narrow sense, even core state legislative activities are not absolutely privileged. Now, with that, let me jump back to the other two slides about prosecution of criminal conduct. Peter, if you'll take the lead at getting me back two slides.
Where you want?
No, one more back. Thank you. Peter's made a couple of allusions to the role of the legislative privilege with respect to criminal conduct. I also was just talking about it with respect to federal charges against state legislators. And I'm in agreement with Peter that the legislative privilege should not become a get-out-of-jail-free card or an escape from being ever put in jail free card for state legislators. But the privilege, if properly construed and applied, may in some instances, may in many instances, make proving criminal charges against a legislator more difficult. And that is a trade-off that I believe was fully considered and understood and appropriately made in creating the privilege in the first place, or preserving the privilege in the first place. And it comes again down primarily to the question of whether we want legislators to be vulnerable to being hauled into court, to be required under threat of judicial action or executive branch threat, to talk about their motives. And even with respect to core quintessential bribery, we don't want a legislator to have to talk about what it was that motivated that legislator to vote a particular way, even if the only thing that motivated it was an out-and-out bribe. You know, that's sort of putting the cart before the horse to say, well, because we know it was a bribe, we're going to ask them what motivated them. We don't know in the first instance where their motive came from, and we're not going to go down the road of asking them and requiring them to talk about it. Now, we still will find some alternative ways to try and prosecute for bribery where we can. And in the federal jurisprudence, the way it's most often articulated is you can establish the promise that the legislator made to perform an official act in exchange for something of personal benefit. And that promise to perform an official act is itself not a legislative act. And you prove bribery by proving the existence of the deal, or proving the existence of the promise. But you can't prove the bribery by showing the official act. And that means you can't ask the legislator, why did you vote yes on this bill? That's core legislative conduct. And that's what both of these slides are getting at. And let me just wrap up with one more minute about getting back to the open government stuff. In the panel this morning, some of you may have been there, for a while as I was listening to it, I wasn't hearing any acknowledgement of the existence of a legislative privilege that might sometimes complicate interpretations of things like a state FOIA or a state open meetings statute. Now, eventually we got there, and I was hearing a number of the panelists this morning mentioning them, that is, mentioning legislative privilege in connection with things like a state freedom of information statute. Sometimes I think there's been an assumption that a state Freedom of Information statute covers legislative materials. That's an area where I would invite you to think carefully about that. Some FOIA provisions explicitly say they're not covering legislative materials. Some don't. The federal FOIA says just that. Ones that don't say that they're covering legislative materials may not be, and even if they say they are, we've got a question about whether a state constitutional provision that provides a legislative immunity would actually allow a FOIA provision to cover legislative materials. As Peter has described, the legislative privilege is at its core a privilege personal to individual legislators. If that's taken seriously, that means the legislature can't waive it on behalf of any individual legislator. And you as legislators can imagine the vulnerability you would be in if a majority of members hostile to you could take away your legislative privilege. So if taken seriously, a FOIA statute that purports to apply to legislative materials may not. In fact, I would argue that a state court ought to accept an assertion of legislative privilege with respect to what are actually legislative documents as trumping a state's FOIA statute. Courts generally require waivers of the legislative privilege to be made by the individual legislator quite unequivocally. And ethics laws are also creating some additional sorts of issues that will require interpretation, just like FOIA statutes and so forth are. I'm going to leave it there, except to just note that I was already going to make sure you understand Peter's treatise is an immensely valuable piece of information in wrestling with these issues. And in addition to the article that I wrote about 8 years ago when I was discovering that lots of state courts weren't seeing the privilege issues in quite the same way or hadn't even had an opportunity to address them yet, I've written more recently about the case of William Jefferson that Peter also made some reference to. And my focus there is really on the FBI's raid of his office, which I found deeply troubling, notwithstanding the fact that there were clear indications that Representative Jefferson had been doing things that he shouldn't do. There were better ways and alternative ways to find that out than to barge into his congressional office and rifle through every single document, many of them clearly privileged, for 18 hours, notwithstanding whatever safeguards the investigators tried to put on that search process. So that's the other article that I referenced here. Thanks.
Thank you both, Professor Huefner and Peter. I'm going to open it up to questions now. If you have a question, you can go up to the microphone in the center, and when you do so, please state your name and what state you represent.
Okay. I'm John Turcott. I'm Director of Program Evaluation in North Carolina. Just an observation, having to deal directly with state agencies and stakeholders of state agencies, I just would like to observe that their conduct when staff go out and in the field and deal directly with them is much more sharp, it's much more threatening, and there's a lot of anti-legislative hostility out there that may not be manifested before you when legislative liaison, lobbyists, and others appear before legislators and committees, because they seem to be more polite there and more diplomatic and more tactful, I would say. My concern is that in that Ohio case and that Michigan case, if that line of reasoning applies to the type of reports and the language that we use as evaluators in reporting our findings to our legislators, if that is the case, if they get comfort in that sort of legal reasoning, it may be difficult for us to say things in a way that we think is most candid to legislators in acting in an oversight capacity. I'll give you an example. Many times a finding is written this way: the agency executive director failed to act when given information relative to the standing or status of their budget or whatever it might be. as opposed to saying the agency did not act in time to, or did not act when they had the information. You see, you could say one thing one way, you failed to, as opposed to did not act. And also the use of the passive voice, when it would be more appropriate to define who the actor was in those cases. So what I would like to know your thinking about is the extent to which legislative staff who are actively engaged with the executive branch and produce documents that are read by legislators. And all this is done under the official realm of a state law and a legislative oversight committee that's factored into that. Is there any protection for the type of communications that I'm describing, or anything that you would advise doing and not doing? I'd like Walker Reagan to hear this, because he's our lawyer there in the legislature. Because if something bad happens, I'm going to go run to Walker and get his advice. So thank you for that.
Yeah, well, in my judgment, that sort of legislative oversight of executive agencies, because it's all related to potential legislative activity, is the kind of thing that is core legislative activity and should be protected. The Ohio decision, therefore, is quite troubling because taken to its logical limits, as long as the request is just for information and not for testimony, just for disclosure of some of that internal discussion, it's vulnerable. Now, the only consolation I have about that Ohio case is it was not the Ohio Supreme Court, it was an intermediate court. So there's still hope to help educate courts about the importance of the privilege for that type of internal legislative activity.
Lucy Weber, State Representative from New Hampshire. We heard about legislative debate repeated to constituents not being protected. What about constituent communications to legislators about legislative business or legislative problems that constituents have? I mean, some of mine have problems that they certainly wouldn't want trumpeted about. And then I'll leave it at that for that one.
Well, so here's how I articulate my view of this, and I think this is also consistent with what federal courts have done with it for the most part. The fact of the constituent communicating with a legislator about a legislative issue is not itself privileged, in the sense that anybody who wants to ask the constituent about it can force the constituent to talk about it. But you cannot ask the legislator to talk about it. You cannot ask a legislator to confirm that it happened. So in that sense, this is a privilege that's quite different from other legal privileges. I mean, it's a privilege against requiring the legislator to respond to questions about their legislative activity. And their legislative activity includes receiving communications from interested parties and constituents about legislative issues. So that's how I'd respond.
This is something that also may be subject to state statute, the Freedom of Information or Government Data Practices Act. In Minnesota, one section of our Government Data Practice, sorry. In Minnesota, one section of our Government Data Practices Act says that communication between an individual and elected official is private data, but may be made public by either the sender or the recipient. So it's private in Minnesota.
Hi, I'm Robin Lunch. I'm a legislative council attorney with the Vermont legislature. And I wanted to get your take on kind of a nuance of a decision that an unpublished decision that we had in the Vermont District Court. A couple years ago, the state was sued by a private company asserting unconstitutionality of a law that I drafted. And I was subpoenaed to a deposition as part of that case. Our Attorney General did move to quash the subpoena, but the judge in a one-page entry order said that I could be deposed, that I could assert legislative privilege for conversations that I had one-on-one with members, but if there was more than one member present, that I had to talk about that. That isn't how we would consider that privilege. So in the deposition, I asserted the privilege where, based on our office policy, not based on the judge's decision, and it didn't go any further than that. But I was curious to know what you thought about that kind of distinction of one member versus multiple members.
Yeah, there are interesting issues that do come up when you've got multiple holders of the privilege involved with respect to the same core information or proceeding. But my response would have been sort of the inverse of that, which is you can't talk about any conversation you have with an individual member unless the individual member agrees to let you, nor can you talk about conversations with multiple members unless all the members agree to let you talk about it.
Yeah. Lawrence Mohammed, Legislative Council, Nigeria. My question is that I want to know the legal status of a legislative staff who is being summoned in a court to testify against or in a legislative function. There is a matter of contention in court being entered in the vote and proceedings. What's the legal status of that legislative staff?
Well, so I see that as sort of related to the New Hampshire example we just had and the Ohio case I described earlier, if I'm understanding your question right. That, I mean, I think legislative staff, as you've described, should not be subject to compelled questioning. Okay. Now, they could, we're talking legislative staff now, and the legislative staff have a privilege that's only an extension of the privilege that is personal to the legislators themselves. And if the legislator who holds that privilege is willing to waive it, then the legislative staff would be free to go ahead and testify. But as we just heard from New Hampshire, courts aren't always seeing it that way.
When I've gone into court on behalf of a legislative staff member, I've always checked with the member that they were allegedly working for to get the member to assert the immunity on behalf of the staff person. The staff person can't be left all by themselves. If they don't have a member behind them, they're out of luck. But with a member, you should not be questioned.
And I've counseled legislative staff who are clearly privy and protecting privileged information to assert the privilege if they have not yet had an opportunity to determine from the principal, from the legislator, what the legislator's view about whether the privilege should be waived or not is. In that sort of gap period, go ahead and assert the privilege until you can find out whether the legislator wants it asserted or not.
I see our time has expired.
Yeah, and if there aren't any other questions, I'd like to thank both of these gentlemen for coming and speaking today. So everybody have a great rest of the evening. Thanks.
Thank you. Lisa?